Hello, my name is Thomas F. Coleman, and I'm the legal director of Spectrum Institute, a nonprofit organization that promotes the rights of people with disabilities in general, and in particular seeks to reform the conservatorship and guardianship laws in various states, proceedings that implicate and adversely affect the rights of people with disabilities. Today, I'm going to speak about some new federal rules that will apply to patients with disabilities. And I'd like to do a screen share here so we can start this off. The new federal rules were issued in May of 2024 by the Office for Civil Rights of the United States Department of Health and Human Services. And the rules prohibit discrimination against patients with disabilities. Today, I want to give you an overview of these new federal rules and how they, in particular, apply to patients with developmental disabilities. But what I'm about to explain to you would also apply to people with other types of cognitive or mental disabilities. The the rules were promulgated to implement two different statutes. The first is Section 504 of the Rehabilitation Act of 1973, which applies to healthcare providers and others who receive federal funds through the uh, Department of Health and Human Services. And also, the second is Section 1557 of the Affordable Care Act, which is otherwise known as Obamacare. Both of these statutes prohibit discrimination against patients in the delivery of healthcare services. And I want to go through this today briefly to explain various sections of the new rules and how they would apply to patients, how they would apply to families that want to advocate for patients with disabilities, and how they apply to healthcare providers. A longer version of this presentation in writing is found in a booklet. You see the link at the bottom there under the Alternatives to Guardianship.com link. And there's a 32-page booklet that explains in some detail, in greater detail, these provisions. This presentation is being made to the Missouri Medical Rights Work Group, which is a collaborative of individuals, agencies, and nonprofit organizations in Missouri that are exploring decision-making options for patients with developmental disabilities. The work group was convened by three organizations. The first is the American Academy on Developmental Medicine and Dentistry. The second is Spectrum Institute. And the third is the Alternatives to Guardianship Project of Human Resources, Inc. That project is a federally funded project that's specifically looking at alternatives to guardianships, and the medical establishment is very much in the focus of that work group. Now, these rules apply to healthcare providers that receive federal funds. That includes all hospitals, 92% of doctors, and almost half of dentists. So a wide range of healthcare providers in the nation are receiving federal funds in one way or another, and therefore these rules apply to them and to the patients who are served by these providers. First, some data on patients in Missouri, and national data would probably be very similar to this. There are 73,000 adult patients with developmental disabilities who have been identified in Missouri. and 217,000 with cognitive disabilities. So somewhere between 200 and 300,000 patients in Missouri have mental or developmental disabilities, but only 30,000 of them are in guardianships. So from this data, you can see that the overwhelming majority of adult patients with mental or developmental disabilities are making their own healthcare decisions. They're presumed to be competent in the law, and in fact, most of them are competent to make healthcare decisions either on their own independently or with the help of others of their choosing. There's also another 1,300 teens in Missouri who have developmental disabilities. They're in a process we call transition to adulthood. 1,300 teens annually are transitioning from being minors to adults. So this patient population is one that the healthcare industry should be paying close attention to, because as minors, their parents are making the healthcare decisions for them. The moment they turn 18, the parents no longer have that right unless it's delegated to them by the patient. The patients themselves have the right despite their developmental disabilities. There are various elements of the new rules that we're going to talk about. First, discrimination is prohibited. Reasonable modifications must be offered to patients with disabilities. Providers must offer and ensure effective communication to and from and with these patients. The patients must be given meaningful access to healthcare services, and that includes meaningful access to the decision-making process. In making judgments about these individuals and their capacity to make decisions on their own or with help of others, providers have to use what's called individualized judgment. Class-based stereotypes are not permitted, or assumptions or biases are not allowed. There's a concept and a process called supported decision-making that these rules now refer to, and we'll talk about that. The rules require healthcare providers to have a compliance officer that assists the provider in complying with these federal rules. There must be a grievance procedure internally within the organization that's established, and employees that are dealing with patients or dealing with policies regarding patient care have to be given training regarding these new rules. First, with respect to discrimination, what's not allowed? So you can't deny or limit treatment due to biases or stereotypes, generalizations, or mere perceptions of the person's disability. The provider cannot refuse to allow the person to have assistance, either the presence of a support person or the use of what's called supported decision-making, or to delegate decision-making to another through a valid power of attorney. What is permitted is basing treatment decisions on individualized assessments, on evidence of incapacity to consent, when that evidence is tailored to the individual, and when the capacity assessment is done by a qualified professional. And also what's allowed are for judgments to be based on the best medical knowledge. Also permitted, the providers can refuse to allow assistance if the patient objects to a particular person assisting. They don't want them to assist. Or if there's evidence of abuse by a support person, then the provider can say no to that support person. Or if there's objective evidence that the power of attorney is invalid. Meaningful access to the healthcare service process must be provided by the healthcare provider. Now, decision-making is a very central component of medical services. Therefore, patients with disabilities must be given meaningful access to the medical decision-making process. There are various levels of patient access to that process. from the most involved to the least involved. The most involved is when the patient makes decisions independently on their own. Next is when the patient has the presence of a support person just to be there and help them and explain things to them. Third is when they have a supporter there who helps them actually makes decisions and gives them advice and other help, but the patient is still up, bottom line, making their own decisions. Next is less involvement by the patient is when they execute a power of attorney for healthcare and delegate to another person the right to make decisions for them. And then finally, the least involvement of all is when a court removes their right to make decisions and the court appoints a guardian to make decisions for the patients. So there's that whole range of from being the most involved to the least involved. And a provider can't just jump to the least involved to recommending a guardian unless other steps are tried. Reasonable modifications. The federal law says, these rules say that patients with disabilities are entitled to have reasonable modifications of normal policies and procedures. This might entail when visits are scheduled. So it's scheduled at a time when the person's operating at their best rather than at their worst. It might take extra time for a visit, or maybe there has to be a second appointment made to give them time to think about it and make a decision. A companion of their choice must be allowed into the treatment room or into the conversation with the healthcare provider. Simple language must be used. Complicated terms, are maybe out of the question. And so the language will have to be simplified for them. The provider may have to use photos or graphics. And then the process called supported decision-making may have to be allowed if it's workable. And oftentimes you won't know that until you actually try it. Individualized judgments must be made. Again, not class-based stereotypes. A disability diagnosis is not the same as a finding of incapacity. Capacity analysis is situation specific. A person generally doesn't have, it's not an all or nothing situation where the person lacks capacity to make all medical decisions. That's a person in a coma would fit that situation, but most patients are not in a coma. So informed consent is situation specific according to a particular treatment. A patient may definitely have the capacity to give consent or refuse consent for a dental treatment involving teeth cleaning or an examination, or in a doctor's office having blood pressure taken or medication prescribed and so on. So it's got to be person-specific, done by a qualified professional with scientifically valid process about a specific decision that's being made. And the law says that we presume capacity unless there's evidence to the contrary. Effective communication has to be ensured for patients with disabilities. If you're making false assumptions about them, that's going to hinder communication with the person. Providers should ask about the communication preferences of the individual. They should allow a support person if requested. As I said before, use images and graphics and provide extra time. Those are a few methods that should be used or considered with respect to communicating with patients with disabilities, especially those with developmental disabilities. Supported decision-making may be necessary to use to avoid discrimination in medical treatment, to obtain informed consent, to have effective communication, and to offer reasonable modifications of policies. So this is emphasized in these new rules, something that previously had either been unknown, not thought about, not discussed, not seriously considered. That's now on the agenda for healthcare providers. The healthcare provider must have a compliance officer if they have 15 or more employees. There has to be somebody on staff who's designated to coordinate the efforts of the employer to comply with Section 504 of the Rehabilitation Act. There must be a grievance procedure and notice of non-discrimination. With respect to the grievance procedure, providers with 15 or more employees have to adopt a procedure that incorporates what's called due process standards, which means there's a fairness and an ability to appeal to a higher authority within the organization, and that provides for the prompt and fair resolution of complaints. Furthermore, all covered entities, regardless of the number of employees, have to give notice to patients of the provider's policy regarding non-discrimination in healthcare services. Providers with 15 or more employees have to provide employee training. They have to adopt written policies and procedures designed to comply with these federal non-discrimination rules. They have to train relevant employees on those policies and procedures. And the relevant employees include those who are interacting with patients and those who are making decisions affecting patient health care, as well as executive leadership and legal counsel for the organization. So there's a lot of training that's going to have to be done to update these employees about these new federal rules. Complaints about violations or alleged violations by providers can be made by patients or someone on their behalf with the Office of Civil Rights of the Department of Health and Human Services. And there are links online and explanations on how to do that. So if a provider is violating these new rules and the patient or patient's advocate file a complaint internally with the provider and it's not resolved to their satisfaction, they can file a complaint with the Office of Civil Rights and start a federal investigation into it. And in that federal proceeding, the administrative proceeding, the patient can be represented by a lawyer or a non-lawyer of their choice. Since this is not a court proceeding, the patient can choose a relative or friend to represent them or to assist them in processing the administrative complaint against the employer, against the healthcare provider. Also, the state of Missouri for hospital violations has an office of the Bureau of Hospital Standards, and they receive complaints about violations of patients' rights by hospitals. Missouri, several years ago, got rid of its own state regulations and just incorporated by reference patients' rights as specified in federal law. So this includes these new rules now under Section 504 and Section 1557. So the Bureau of Hospital Standards staff are going to need to educate themselves about these new rules and how they apply to hospitals, doctors, and dentists, and others that are providing healthcare services to patients with disabilities, and to receive complaints from such patients or people on their behalf if the patient feels that the hospital in Missouri has violated their federal rights. Violation of a federal right equals violation of state law as well. And there's a complaint form online that can be used for these complaints. So anyway, that's a quick rundown. As I said at the beginning, there is a 32-page document with much, much more in detail about how this all applies. And you can find more information about the Missouri Medical Rights Workgroup online at alternativesToGuardianship.com. Again, this is a federally funded program that the Alternatives to Guardianship Project is funded through the Missouri Developmental Disabilities Council. You can also email me if you'd like, have any questions, at tomcoleman@spectruminstitute.org. That is Tom Coleman at spectruminstitute.org. So I hope this has been helpful. I know it's a lot of information, but you can always go back and listen to it again or look at it again, and or shoot me an email if you have any question on it. And I appreciate you taking the time to educate yourself about these new federal rules. So with that, I will say goodbye and thank you again.